Anil, Nandlall.
Thank you very much, sir. Can I have 1 second? So, sir, again, I rise, and it is with regret that I have to register my objection to the motion that is before the House. Sir, no doubt the distinguished member has espoused the importance of accountability, transparency, and good governance. Those are concepts, sir, that we are all wedded to. However, sir, that is not the issue that is before this House. And our population who are following must understand what the issues are. If the issues are, as my distinguished colleague articulate them, we stand in support. We have never deviated from the canons of transparency and accountability. So that's not the issue that is before the House. The issue that is before the House, sir, is one that is even more or equally fundamental. And it is the procedure that we govern ourselves by here. We, sir, as an institution created by the Constitution, we enjoy great autonomy in the way we conduct our business. The Constitution says that Parliament is free to regulate its own procedures by its own rules. Our Constitution is established upon the doctrine of separation of powers, and that doctrine entrenches even further our independence, and most importantly, precludes the judiciary from coming into the business of the Parliament and trying to regulate, or to, not to use a harsh word, interfere with the intramural affairs of the National Assembly. Those protective safeguards are there, and members of this House are very well aware that only recently the Honorable Justice Damoni Young reiterated those principles in a well-researched judgment that the judiciary and no other institution of state must influence the way that we conduct ourselves. We have that freedom. And therefore, sir, it is imperative and incumbent upon us to ensure that we regulate ourselves with propriety, that we regulate ourselves in accordance with our standing orders, and even most importantly, that we interpret those standing orders in a sensible way. Now, every institution, like the Parliament of Guyana, has an inherent power to guard its processes from abuse, and must conduct its business and interpret its rules in such a way that it does not allow abuse of its process and its procedures. In every institution like the Parliament, there has to be mechanisms that prevents redundancy, repetition, and monotony, for want of a better word. The judiciary has similar principles. So when a case is litigated before a court, and whatever the outcome of that case is, it cannot be relitigated before that court. These standing orders, sir, capture that principle in many respects. The principle in the judiciary, as the lawyers here will tell you, it's called res judicata, meaning that a matter has been heard and determined by a tribunal that has the power to do so, and it can be taken to that same tribunal to argue it back again. What is the utility of that rule? That you will have continuous litigation over and over again. Transposing that principle to us on this side, in this house, you have rules of similar effect and purport. Now, sir, it is common ground in this house that motions are the preeminent vehicle through which we debate matters in this house. Motions. So when a motion comes to the tribunal that has the jurisdiction to determine admissibility, that tribunal has a responsibility to apply those rules to ensure whether that motion is admissible in the first place. And we have Standing Order 26 that speaks directly to that issue. It says admissibility of motions. So this is the preeminent regime of principles and criteria which must apply in determining whether a motion is admissible or not. Now, it is common ground also that a motion came before the House, the subject matter of that motion, the quintessential issue in that motion was the configuration or the then configuration and composition of the Public Accounts Committee. With that proposition, no one can disagree. The composition was in a particular fashion, and it was felt, rightfully or wrongfully, that that composition ought to be revisited. And a motion to that effect was brought to this assembly, debated and determined by votes in a particular manner. I don't think anybody will dispute that. I don't think that anyone reading this motion and listening to its presenter a few moments ago can be in doubt that this motion seeks to undo that which was accomplished by the previous motion. That is to say, a reorganization or a reorganization of the composition of the Public Accounts Committee. The honorable member said so repeatedly, and he gave reasons why. So, in his reply, or in others who will speak after me, cannot, in good faith and with credibility, come here to say that the pith and substance of this motion is about anything other than a revisiting of an issue that has already been determined by a motion. That is what this is about. So, let us go to admissibility of motion, which I believe is the first rule that ought to be applied when a motion comes. You have to determine whether it is admissible or not. There may be other rules that you may have to consult, but this regime of rules ought to be the governing one, and sense and purpose must be given to the interpretation of these rules to make sense. Now, it cannot be that this House will find acceptable, or any parliament for that matter, will find acceptable, especially since decisions here are made by vote, will find acceptable a practice of bringing motions upon motions to determine issues already determined by motion. If that is the rule, or that is the practice, then we will be here every single session redebating and redebating a matter that has already been settled. When that occurs, that becomes an abuse of the process of the parliament, as it is an abuse of the process of the court by the doctrine of res judicata to relitigate a matter that has been litigated. So unless we apply that rule sensibly, Mr. Speaker, in an adversarial parliamentary system, because I am only here to express my opinion. So, Mr. Speaker, my opinion is what I'm here to express based upon the law and the interpretation of the law. So, Mr. Speaker, in an adversarial system, in an adversarial unicameral legislative assembly, you will have one side voting one way and the other side voting the other way. If it is that it's a free-for-all, and that one can bring a motion at every sitting of the parliament, all we will be doing, Mr. Speaker, is debating motions and voting against them over and over in a cyclical manner. That does not make sense. That cannot be the business of this parliament. That cannot be the function of the parliament. And that is why, in their wisdom, the drafters of the standing order, drawing from a tradition dating back to 2nd of April 1604. 2nd of April 1604 is when the rule was crafted against repetition on motions. And I will deal with this a little later. And out of that rule and rationale came the current Standing Order 26. In order that the motion may be admissible, it shall satisfy the following conditions. Shall, we know, is the mandatory command form. Shall, it shall, so there's no discretion here, Mr. Speaker. It shall comply with these requirements. If it does not, the reverse is, if it does not, it is inadmissible. And that is why I'm saying that this has to be the governing standing order. And I'm going to deal with another standing order that allows for a rescission. That standing order must bend and bow to the glory of the governing standing order on the matter. Because a motion that does not satisfy this cannot be admitted. So no other standing order will even come into play. And that is the absolutionist position. And what are the issues that this standing order prohibits? It says, E, let me go straight to E. It shall not revive discussion of a matter which has been discussed in the same session. Why the same session? Because it is expected that after this session is complete, this session will run its course. The people, the electorate, have elected one set of parliamentarians. They are expected to last for that session, that elected term of 5 years, and the new body will be elected after those 5 years, and that new body can revisit or can deal with a matter that was determined in a previous motion, in a previous session, because they have a fresh mandate and there may be a new parliament. So the thing has great sense in confining it. It means that you have one session to determine what your business is, and you are not to repeat it. There is a similar standing order that speaks to anticipation of legislation, and that you can't have a motion that will debate a matter that there is going to be a bill coming on in the same session. Why? That is another rule against repetition and abuse of valuable resources and time of the Parliament. Mr. Speaker, we have to understand the rationale for these rules, or else we will never be able to interpret them and able to decipher the intention of the framers of the rule. These rules can be read literally. They are expected to be read with elasticity that would enable them to be interpreted in a reasonable manner, or else the rule book that will to govern us will be this thick. So it will be this thick. So we have to read them. We have to read them sensibly and purposively. So it says, it shall not revive discussion of a matter which has been discussed in the same session. Now that is the fundamental prohibition. Have we discussed this matter in this session before? Have we discussed this matter, which is the configuration of the Public Accounts Committee, the composition of the Public Accounts Committee before in this session? The answer is yes. And if the answer is yes, the motion is inadmissible as not having satisfied that basal and basic requirement. And it is as simple as that. But Mr. Speaker, like every institution, we don't have appellate procedures here. So once we make a decision, once we make a decision, because of this rule, we can't revisit it. We can't revisit it. Now, in good sense, I know the Speaker has admitted it.
You're talking academically.
No, I know the Speaker has admitted it. That doesn't mean I can't speak against it admissibility. I am rejecting the motion and I'm chronicling all my reasons for rejecting it. I am chronicling all my reasons. So, Mr. Speaker, in recognizing that there must be due flexibility in our ability to review once all of us agree, Parliament has given us a residuary power of review. And that is how that power of rescission is to be interpreted. Mr. Speaker, you don't have to accept my word, Mr. Ramjatan. Listen, I am quoting now from Erskine May, the 13th edition. It speaks to this vexed question of revisiting matters already settled.
You're wasting the Parliament's time.
So, Mr. Speaker, the rule urged on the 2nd of April 1604, and this is the rule I'm speaking about, that a question being once made and carried in the affirmative or negative cannot be questioned again, but must stand as a judgment of the House. That's the rule. Once determined, stands as a judgment of the House. Also, by a rule formally enforced, a second bill at variance with the provisions of a bill passed during the same session could not be introduced. Further, rescission is opposed to the spirit of the existing rule that no question shall be offered which is substantially the same as the one which judgment has been expressed during the current session. So they are saying to you that rescission offends that rule. They are admitting that. That's what Erskine May is saying.
The Speaker is appealing your ruling here.
Mr. Speaker, and I continue.
You say you
But the practical, and this is the rationale, Mr. Speaker, but the practical inconvenience of a rigid rule, especially where a house as a whole, the house as a whole wishes to change its opinion, has proved too great for anybody confronted with the ever-changing problems of government. So you understand why they permitted why they permitted the rescission rule? To give the House an ability as a whole, when it decides as a whole to revisit a particular matter. Only then. Only then. Here, there is no decision of the House as a collective. A rescission motion is almost a unanimous motion. That is what they're saying here. When the House as a collective said, you know what? We need to revisit that thing in our common interest. Here, it is not a common interest. It's a partisan interest. So the rescission rule is inapplicable. And it continues. It continues, Mr. Speaker. And the rule prohibiting reconsideration of a decided question has come to be interpreted very narrowly. That rule that allows you to come back must be interpreted very narrowly so as not to prevent open rescission when it is decided that is desirable. Not to open rescission must be done very narrowly. It continues. The power of rescission has been exercised only in the case of a resolution resulting from a substantive motion, and even then sparingly. Sparingly. It continues. It cannot be exercised. It cannot be exercised merely to override a vote of the House. Take notes, Mr. Speaker, please, and Mr. Clark. It cannot be used merely to override a vote of the House. This motion seeks to do that. Merely override the vote of the House. It cannot be exercised merely to override the vote of a House, such as a negative one. In this case, it was a positive one. Proposing a negative question a second time for the decision of the House would be, as stated earlier, contrary to the established practice of Parliament. Bringing a vote, determining a question already determined, would be contrary to the practice of the Parliament. Sufficient variation would have to be made. Sufficient variation would have to be made. That's the first point. What's the variation here? What is the variation here? It is the same reconfiguration of the composition of the Public Accounts Committee. Absolutely no variation. Sufficient variation would have to be made, comma, not only from the form, but also from the substance of the rejected question, to make the second question a new question. Oh my. You have to have substantial and substantive difference in the question itself, so in order to render it a different question, for it not to offend the rule. So, Mr. Speaker, you cannot just add the titular label of rescission on top of a motion and bring back the same question. That makes a mockery of the rules. And that is what, Mr. Speaker, I dare say is what the honorable member is guilty of. It's a flimsy disguise. A flimsy disguise of the question, Mr. Speaker. So, Mr. Speaker, I come to the standing order. Having said everything that I have said, Mr. Speaker,
Irrelevant and tedious.
we go to Standing Order 25.3.
Let's look at the next one.
And Standing Order 25.3 must be interpreted against the backdrop of the learning that I've imparted to Comrade Ramjatan, the honorable member, who came in here completely uneducated on this matter. It's against that backdrop that we have to interpret 25.3, upon which the motion is predicated. Where a question for debate has been proposed, debated and decided, it shall not be competent. It shall not be competent for any member to raise a question substantially identical thereto in the same session, except upon a substantive motion for rescission. Mr. Speaker, after I have said all of that,
You still got the votes again.
the prohibition against the substance of it,
Still got the votes again.
you simply can defeat
Right.
all of that by adding rescission to the title of the motion, and it defeats all the rules and all the rationality and all the basis against repeating a motion or a question already decided. So this standing order, Mr. Speaker, has to be interpreted narrowly and from that perspective. So when a rescission order motion comes to the House, it has to raise a question that is substantially a different one. And I am not saying so. Or Sky the authority that we have accepted as the authority to guide us, says that. That is how it.
Speaker's ruling on admissibility is final.
So, Mr. Speaker,
It's alleged.
Mr. Speaker,
Can read that.
with those remarks,
And votes.
this motion is inadmissible ab initio. It is on the floor.
Thank you.
I ask you, sir, to revisit your ruling in admitting this motion, and if Your Honor refuses to refuse or exercises your discretion against my request of reviewing it, then I invite my colleagues on this side to reject this motion as an abuse of the process of this House and in violation of the standing orders. Thank you very much, Mr. Speaker.